The envelope arrived on a Tuesday morning, and it looked official enough to make my stomach drop before I even opened it. Thick cream paper, embossed seal, certified mail sticker. Inside was a summons. The Lakewood Ridge Homeowners Association had filed a civil complaint against me in county court over a fence I built on my own land. I'm Marcus Del Rey, and I've owned 11 acres of lakefront ranch property in Lakewood Ridge, Texas, for going on 7 years. My land runs from the edge of Creston Drive all the way down to the eastern shoreline of Barton Lake. And that fence, that beautiful code-compliant cedar split-rail fence, sat entirely within my surveyed property lines. Not one post was outside them, but the HOA's attorney, a man named Philip Granger, claimed the fence obstructed community access to a shared recreational corridor. That phrase, shared recreational corridor, would become the center of everything that followed. And by the time this story ends, that corridor would belong entirely to me. Before we go any further, if you've ever had an HOA come after you for something you built, planted, parked, or painted on land you legally own, subscribe to HOA Problems right now. We break down real property disputes using actual U.S. property law frameworks every single week, and what I'm about to walk you through could save your home. Let me give you the full picture. Lakewood Ridge is a mixed-use residential community. About 340 homes, a clubhouse, 2 boat ramps, and a gravel access road that cuts along the eastern edge of my property. That road is called Shoreline Pass. The HOA had been using it for years as a community thoroughfare to reach the lake's public boat launch, and nobody had questioned it until I started building. I built a perimeter fence to keep my livestock, 3 horses, and a pair of longhorns, safely contained away from the shoreline. The fence was designed by a licensed contractor, built to Texas Agricultural Code specifications, and never touched Shoreline Pass. Or so I thought, based on 7 years of assuming where my property ended. That assumption was about to get legally tested. The HOA's board president, a woman named Sandra Kirch, drove up to my gate in a white golf cart exactly 4 days after I broke ground. She was wearing a lanyard with a laminated badge that read, HOA Enforcement Officer, which I later learned is not a legally recognized title under Texas Property Code Chapter 209. She told me, arms crossed, "That fence is going up on community land, Mr. Del Rey. You need to stop construction immediately." I asked her calmly, and I want to emphasize that word calmly, what documentation she had showing community ownership of the land the fence was on. She said, "It's in the CC&Rs. Everyone knows Shoreline Pass belongs to the association." I told her I'd like to review that documentation. She said she'd have it sent over. That letter never came with any deed reference. What did come 8 days later was a formal violation notice. Printed on HOA letterhead, it cited Article 7, Section 3 of the Lakewood Ridge CC&RS, which, I'm paraphrasing, prohibited members from erecting structures that impede access to designated community areas. The fine? $250 per day until the fence was removed, beginning immediately. I did not panic. I did what every property owner in a dispute like this should do first. I ordered a certified boundary survey from a state-licensed surveyor. His name was Gerald Foss, licensed by the Texas Board of Professional Land Surveying. Gerald took 3 days, used GPS reference control monuments, and produced a stamped plat map that showed every inch of my 11 acres. What that survey revealed changed everything. Shoreline Pass, the gravel road the HOA had been using as a community throughway for at least a decade, ran entirely through land that was legally recorded in my name at the Barton County Appraisal District. Not HOA common area, not a dedicated public road. My private property, every inch of it. I pulled my original deed from a waterproof safe I keep in my office. Then I drove to the Barton County Clerk's office and requested a certified copy of the title chain going back to the original subdivision plat from 1987. That research took most of a morning. What I found was critical. Shoreline Pass had never been dedicated to the HOA, never platted as a community easement, and never transferred by deed to any association entity. Here's the legal education piece for everyone watching. In Texas and in most U.S. states, A road or pathway on private land only becomes legally accessible to a community HOA if one of three things happen. It was dedicated on the original subdivision plat, conveyed by a recorded easement instrument, or acquired through adverse possession after years of open, hostile, and continuous use. None of those three applied here. Meanwhile, Sandra Kirch escalated. Step 3 on her ladder came in the form of a letter from HOA attorney Philip Granger, threatening to place a lien on my home if the fence wasn't removed within 30 days. He cited the ongoing daily fines, now allegedly at $4,750 accumulated, and warned of further legal remedy, including injunctive relief. I hired a real estate attorney named Vivian Okafor, licensed in Texas, who specializes in property rights litigation. Her first move was to send a certified response letter to Philip Granger requesting the recorded easement instrument, plat dedication language, or any deed that established HOA rights over Shoreline Pass. She gave him 14 days. His office sent back a copy of the CC&Rs, which referenced community access corridors in general terms, but not a single recorded county document. Step 4 came on a Thursday afternoon. Sandra Kirch and 2 board members, a man named Roy Talbert and a woman named Denise Crow, walked onto my property without notice, without consent, and without legal right, carrying measuring tape and a camera. Under Texas Property Code Section 209.007 and common law trespass principles, this was unlawful entry. I documented their presence on my security cameras, noted the exact time, and had Vivian send a formal trespass notice that evening via certified mail. The HOA board called an emergency meeting and scheduled a public fine vote. Under their bylaws, the board could theoretically increase my fine to $1,000 per day with a majority vote. This was step 5 on the escalation ladder. The public spectacle vote, designed to embarrass and financially pressure homeowners into compliance. I attended that meeting with Vivian Okafor and a manila folder full of certified county documents. When Sandra Kirch stood up to present the case against me, Vivian asked to address the board before any vote. She placed the Gerald Foss certified survey with its state surveyor seal on the table. Then she placed the certified title chain from the county clerk. Then she placed a printout of Texas Property Code Chapter 209, specifically the sections governing HOA, fine authority, and the procedural requirements for imposing fines on members.